I think most of the attendees know this, but we're not creating a lawyer-client relationship here or giving specific or customized legal or tax or investment advice. This is just general information on legal topics, and we're really glad you're here.
Great, thank you. All right. Well, my name is Tony Yang. I run the growth team here at Mucker. And all that really means is I get to work with a lot of very smart and inspirational founders to help them grow their companies. But really today's star is our very own Amanda Busch. She's the general counsel here at Mucker. And as she just shared it in the last slide, today she's going to be teaching or covering several topics around the legal area for startups. And a lot of times I know in working with many of you founders that this is not always top of mind. It's nonetheless certain topics that we're going to cover today are very important. So Amanda, really looking forward to having you share your knowledge with the group, and I'll hand it over to you.
All right, thank you, Tony. So I agreed a while ago to do a legal 101 and overview presentation. And as I started to put the information together, consolidating or attempting to consolidate all of the things that it's helpful for founders to know on the legal side as they start out with building their companies really gave me a renewed sense of appreciation for how much all of you have going on at any given point in time. So there's a whole lot, and obviously we can't cover all of it here, but I hope that we'll be able to touch on some subjects and provide you with some helpful information as you sort of go along your way building your companies. So we'll talk through the formation process at a high level, how to think about the founding team and what to consider as you're building out a team of employees. We'll briefly touch on the basics of commercial agreements, and then spend some time thinking about what changes when a company begins to raise outside money and what you need to know and consider there. And then recognizing that, like I said, we can really only scratch the surface in terms of the potential concerns here. We'll just end with highlighting some other things to make sure you're keeping on your radar and getting the additional support you need when the time comes. So, most founders, when they start out at the beginning of their journey, you're probably spending some time just kicking around an idea or ideas, maybe starting to create a vision for your product or your company or the underpinnings of your technology. And at this point, there's really not a whole lot that you need to be worried about from a legal standpoint in the very early days. If you are an employee of another organization, that could be an exception. So you want to be very careful to understand your obligations to any current employer if you're doing this as kind of a side gig at the beginning. And you want to make sure you're working on your own time without any resources of your employer, and basically that you have the right to generate whatever you're building and own it outright. Because one of the biggest headaches that a company can create for itself is a question of who owns or has a claim to the intellectual property that is critical to their business. So be aware of those existing obligations or even any hint of existing obligations in that regard. But otherwise, at the very beginning, you're just building, and that's great. But at some point, it's probably going to become clear that what you're working on has some traction. You want to invest more time in it. Maybe it's going to become a full-time role for you. And so at that point, that's when you really want to think about what kind of entity you want to house your business in. When you're working on your own in those early days, if it's just you're kind of working as a sole proprietor. There is no legal distinction between you and your company. That means that any income it generates is all yours from a tax standpoint. Any losses it generates are all yours from a tax standpoint. Also, any liability it generates is all yours from a legal standpoint. And so for that reason, primarily, this is not how most people choose to operate for very long. So you'll want to consider whether you might want to form a partnership, a limited liability company, or a corporation. Those are all entities with separate legal distinctions. They have, I generally point to tax treatment and limitation of liability as features of each different type of entity. A partnership is a legal entity that can limit liability. There are lots of different ways to do it through contract. There's often one partner, one member that may have unlimited liability. But the key feature, I think, that informs this choice for most business owners is the tax treatment. So the income and the losses flow through to the partners themselves. So it could be attractive in theory if you're generating a lot of losses, or if you know the proceeds will always be distributed, because the money that's generated, those returns will be taxed only at the partner level. And that makes it distinct from a corporation where you'll see it's going to be taxed twice. A limited liability company, under most state laws, kind of attempts to combine attributes of a partnership and a corporation. So you have the flow through taxation. You also have a more complete limitation of liability available to the owners. A corporation has the most comprehensive limitation of liability. It's a whole separate entity. It is owned by the stockholders and managed by a board of directors. I referred earlier to the tax treatment being less favorable in a lot of perspectives, because the corporation itself has a tax obligation. And then when distributions are made to stockholders, the stockholders also have a tax obligation. But it also has the most flexible capital structure. It's relatively easy to amend a company's charter. It's relatively easy to transfer the ownership interest, and it's easy to have a really distributed ownership of the entity. And it is also, for some reasons we don't really need to go into, often required by most venture capitalists. Partly that's because there is a whole lot of settled law about how different matters are treated when it comes to the liability of directors or disputes or mergers. Like, there's a lot of known quantity when it comes to corporations, particularly under Delaware law. And so they are the most flexible ownership method, and where we will spend kind of most of our time as we go through this presentation, simply because they are the most common in the startup world. And then whichever entity selection you make, you want to make sure that you know who's in charge. So in a corporation, the board of directors has the ultimate oversight responsibility, and they appoint the officers who are in charge of day-to-day management. In an LLC or partnership, that's usually called a board of managers, and they are responsible for the eventual oversight. They can also appoint officers. So kind of good to know a little bit about that vocabulary, and a little bit about like what you're stepping into as a founder. Most of the time you will be in both of those roles: director and officer, manager, officer. You're doing it all, which you probably already know.
Hey, Amanda, I have a quick question that I sometimes hear in the startup community, not necessarily in Mucker's community, but just overall, which is, if a founder starts off and incorporates their business with one particular type of entity, is it possible for them to switch? And is that advisable at some point?
It most often happens when someone has formed as an LLC, and then they want to take venture funding, and so they need to change into a corporation. It is possible. It is more complicated. That there is generally like more variation in the structure of LLCs and LP limited partnerships at the early stage than you see in like early stage corporations. So there's how complicated it gets depends on the details of those entities. The LLC to corporation conversion we see from time to time. The main problem with it is one that you'd want to jump in the weeds with a tax expert on. But basically, the risk, as I understand it, is that when it's converted, there are limits to the ability to make it tax-free. And so there's a risk that owners in the LLC may have to recognize some kind of gain in the change in value between when they entered the LLC and when they get their corporate shares in return. And there are ways to avoid that, but I think that the things you need to do to avoid an adverse tax outcome either require a lot of forethought or they require a lot of expense to maneuver at the moment in time when you're changing, or both. And so if you know that eventually your path is likely to be, um, you're going to raise money from venture investors or you're going to go public, you probably, I think those are sometimes hard to know at the outset, but you're probably going to be better off having formed as a corporation to begin with.
Great. Thanks.
So just a little bit on the nuts and bolts of kind of creating a C Corp, what we call a C Corp under Delaware law. So, and I'll back up a bit and say, like, I'm focusing on Delaware law because it's the most common. Things are similar but not identical under other states' laws. The C Corp designation distinguishes it from an S Corp, which is actually the same entity, but an election that you can make for tax purposes where you avoid that double taxation. But there are some kind of strict limitations on how and when you can make that election and use it. And one of those is you have to have a limitation of 100 stockholders. And so, again, if you're growing a company that's going to, grant shares to employees and bring in investors, like it's probably not in the long run practical to do an S Corp. If you're going to operate forever as a, small business and really closely held, it may be worth a closer look at that designation. But in any event, when you're establishing a corporation, you kind of have some critical founding documents. The sort of fundamental one is the certificate of incorporation, also called the Articles of Incorporation, also sometimes called the Charter. And that is the legal organizing document that's filed with the state. So a corporation doesn't exist until it's filed. And, it will set out kind of the basics of what the corporation is. It will authorize shares to be issued. It'll set like a par value. It will specify the voting rights attributable to the shares, which is typically 1 vote per share. And so you kind of have to do that before you can do the rest of these things. So, you file the certificate of incorporation. It's signed by someone who's designated as an incorporator. And then there's a consent of the incorporator where they identify who will be the board of directors initially. And then the board of directors will sign this initial board consent where they will adopt the bylaws, which I've put under founding documents because they're pretty central to how the company ought to be run. The bylaws kind of set the internal rules in terms of how, like, who can call a meeting and how many directors will there be? How do we determine how many directors will there be? What are the quorum requirements? What are the conditions attached to the shares? So if there's going to be certain transfer restrictions or rights of first refusal over the shares, that stuff will be contained in the bylaws. They're usually very long. There are usually a handful of sections that you might refer to over time, but they're a good thing to know about and a good thing to make sure you have like a workable set of bylaws at the outset. And so the initial board consent, in addition to adopting the bylaws, will also appoint officers, designate signature authority, take care of some administrative matters like, the officers to go and get an employer identification number from the IRS, determine the fiscal year of the company, maybe authorize the setting up of the bank account. And then also, and usually pretty important to founders, will approve the initial stock issuances and the related agreements for those issuances. And so once the board has done that, then you can go ahead and issue the shares. You may also, in connection with those things, have a couple of tax and securities filings to take care of. I mentioned the EIN application. If you've issued shares, usually if you're issuing shares, either the shares need to be registered, which they never are when a company is formed, or they have to be exempt from registration. And there is a whole securities law regime that we will not really touch on, other than to say under federal law, usually the relevant exemption doesn't require any filing, but it could under state law. And so that's something to just give a little bit of attention to as you are getting started. And then if you have founder shares subject to vesting, there may be some beneficial tax filings to make in connection with that. So there's a handful of things at this stage where you could, there are different ways to get things done. You can use a quick online product to do some of this stuff, but if you are doing that, read the fine print about what may be required in terms of these specific kind of government related actions, or rope in an attorney quickly to help you make sure you haven't let anything fall through the cracks, because there are a couple things here where if you get it wrong, it can be a real pain to fix, or it just like can't be fixed, and it can really trip you up down the road.
Amanda, regarding the certificate of incorporation, is the state that the company needs to be registered in selected by, whichever state you decide, such as Delaware, or does it have to be where the founder is located?
Oh, that's a good question that touches on something else that I probably should add to this slide for the future. So you can incorporate in Delaware regardless of where you are. You may also need to do what is called qualifying to do business in the state in which you are located. So that's a separate filing, but by incorporating in Delaware or whatever state you choose, you're going to be governed by Delaware law, like by default. So stockholder rights are going to be governed under Delaware law. Which approvals you need to get if you are doing a merger will be governed by state law. What are the rights and obligations of the board, duties and obligations of the board, I should say, that'll be governed by state law. And like I was saying earlier, part of what's attractive about Delaware is that those things are settled, and people, experts in the legal fields and related areas, are pretty well versed, and it creates some certainty around how certain actions may be perceived by the courts if they're challenged by minority shareholders or something like that. There's a slight caveat where, like in certain states, if you have enough activity, and California is one of these, if you have enough California activity, even if you're a Delaware corporation, there's a provision of California law that says, well, you also have to give minority shareholders these protections. But that doesn't mean you have to file your certificate of incorporation there. It just means it's one more thing to be aware of when you go out to get a vote of the stockholders to do an equity round or to sell the company or something like that.
Great, thank you. We do have a question coming in from the audience regarding the previous slide where we were talking about changing from one type of entity to another. The question is, if a startup was formed under an LLC in the beginning and wanted to change to a C Corp, is it less complicated when there has been no revenue or no money made yet?
Probably, but it depends. If they have taken investment into the LLC, that would set a value on the basis of the partnership interests. I'm not sure it's that straightforward.
Great. And then we have a quick question regarding the amount of shares. Don't know if you're going to get into this a little bit more detail or if this is out of the scope of this particular presentation, but I'll ask it anyway. This is from the audience. Do you have a recommendation for the total amount of shares and nominal value at a time of incorporation?
Yeah, I actually started to put this in and then didn't, but I'm glad the question is being asked because I will cover it if it's helpful. It doesn't matter very much, but if you shouldn't be afraid to authorize a high number of shares. There are two sort of denominators when you think about what your ownership is. One will be the total shares authorized in the charter, and one will be the number of shares outstanding. And so those are the shares that have been issued to date. The authorized share number, if you make it a very high number, you don't want to then issue up to that maximum number. If you do that, then you have no more shares to authorize. And so as you grow, you will have to go and amend your charter to add shares every time. You usually want to leave room. I did not put this on the initial board consent list because sometimes it's there and sometimes it happens later, and we can talk about it later. Like at some point, you'll probably adopt like an equity incentive plan or a stock plan to cover grants to employees. You want to leave some space there to be able to issue those shares without having to go amend your charter. If you're a solo founder and you're like looking for the right co-founder for a while, you probably want to have some dry powder to be able to grant those shares as well. So the authorized share number, you can make like 10 million. And then if you're a solo founder, maybe you give yourself 6 million and you own only 60% of the authorized shares, but that doesn't really matter because you would own 100% of the outstanding shares. And any decisions you make, any required votes are based on the shares outstanding. But you'd still have that flexibility in terms of authorized shares. But you can do the same. I mean, I've seen companies form with 1,000 authorized shares and 100 million authorized shares. There is, I can't get into a lot of detail on this because I'm just not, I haven't gone into the weeds. There is, I think, some Delaware filing where they might calculate a tax due based on like the number of authorized shares and the par value. And so some people don't want a high number for that reason. But I believe there is an alternative way to calculate that fee. So I don't think that should scare you off. But if that's something you're really hung up on, I would suggest you just talk with a lawyer or a paralegal who does this all the time and make sure you understand it and are comfortable with the outcome.
Great, thanks.
Right, so moving on, once your company has been formed, you really, if I could wish something for every company starting out, it would be to just try to implement some kind of process around like corporate governance, which if you're a solo director and a solo founder could feel very silly. But I think having a record of the major things that happen within a company could be extremely valuable. And so while these concerns really flow through the whole life cycle of a company, this feels like as good a point as any to address them. So, I think of good corporate governance really is just like implementing a productive process to ensure that decisions are made and documented well and that the company is well run. I think we'll next get to some of the board duties, and there's some protection for the board that's available through doing this. But it's also, I think, helpful to kind of force consideration of who has the decision-making power in certain circumstances. So we talked about, the outstanding shares and things that require a stockholder vote, which would include like a new equity financing, for example. Like if you're the original founder and you own those 6 million shares and then you have brought on more people and issued, 6.2 million shares, and we would have had to authorize more than the 10 million, but we'll ignore that. Like you no longer can make that decision by yourself and have it be a valid corporate action. Similarly, if you're a sole director, but then you increase the board, you add another director, like the director needs to, or the board needs to make the decisions together based on whatever requirements are set forth in the bylaws. Or if not in the bylaws, the defaults in Delaware law. So it's just, I think, sometimes by writing things down, even if it's not, anything very formal, or putting a presentation together, just creating some sort of record of how and when those decisions are made, it can be very helpful in the long run. And it can avoid things like, one of the important things the board does is approve share issuances to people. So to the extent there's ever a question about when was this issuance actually made, did the board approve it, how many shares, like is an employee saying, well, you told me you'd give me, 100 shares, but you gave me 80, like, we have, like, having a record in the board documents is extremely valuable for those things, and can also help with things like tax questions that could arise if there's a question about how much shares were worth when they were issued. And also, if you're fundraising eventually, having these records and kind of the history of the company available for an investor to perform diligence can be like really helpful to making that a smooth process. And I think throughout your experience as a founder, you probably have moments where you're thinking like, is it worth calling a lawyer? They're very expensive. And so, this is yet another area where you might find yourself thinking like, do I need to have someone else draft a board resolution or attend my meetings as an observer, or prepare minutes of the meetings? And so I think that that's a really individual decision. And it's a case by case answer. I would say never a bad idea if you're sitting on excess cash to make sure you have the right expertise, but I know that that's often not the case. So I would just say, like, consider like how much time and attention you are otherwise devoting to this. If you're lying awake at night worrying that you might need a different kind of approval than you've made, I would call someone. You have a lot of things to do. And if you're growing really fast, if you have a lot of specialized rules and regulations applicable to your industry, if you're just, growing fast enough that like one little hiccup could kind of have a domino effect down the road, like those are, I think, signals that it really is worth making that call. And recognizing it does get expensive, I think that investment can often be justified in the long run. Um, I'll just say quickly on the board of directors, founders are frequently also directors and have obligations to the company. They are ultimately responsible for overseeing the company and supervising management. There are fiduciary duties, and I'm going to move through this quickly just because I want to get to some other things, and this hour is going really fast. But there's, duty of care, which just says really that you need to pay attention and inform yourselves of what's going on and act with the level of care a reasonable person would use. And the duty of loyalty, which basically says you're obligated to act in the good faith interest of the company on an informed basis. And if you are taking an action in an honest belief that it's in the best interest of the company, like, you are likely to be protected by something called the business judgment rule, which is this concept under Delaware law that, like, we know you won't get it right all the time, but if you reasonably believe that you're acting in the interest of the company and you're acting in good faith, you probably aren't going to be subject to personal liability. So there are some other parameters around board liability and exceptions to it, like corporate waste. You can't just go out and spend your investors' money or the company's money on whatever you want. And you can't, take opportunities under the duty of loyalty. You cannot take opportunities intended for the company and kind of hoard them for yourself. So again, like, this isn't meant to be scary, but just know that there is a heightened set of obligations that come with being a director. There's a list of some best practices, and I would just say we've kind of touched on them, like documentation, avoid conflicts or appearance of conflicts, call in experts to inform your decision making, pay attention, communicate with management, and maintain confidentiality. And so I'm just going to keep moving on so we can get to some other things I think you'll care about, starting with just founder team considerations. And allocation of founder equity, I think, is one area where teams can get a little bit hung up. Founder shares are typically going to be common stock. They're typically going to have one vote per share. And so that means that how many shares you own determines how many votes you get, which determines who has control over the big decisions. And, there's not a single right way to allocate shares among team members. I probably don't even need to tell you that. Like, the amount of time people are contributing, like what they are contributing in terms of cash or expertise, all of those things are valid considerations. I think the main things that I would encourage founders to think about are, like, what happens if someone walks away? How much of the company are they taking with them? What happens if you don't agree on the next path for the company? So vesting can help to smooth over some of those things. If you're uncertain about what someone is going to contribute or whether they're going to, finish creating an asset that's really important to the company. If they create that, maybe their stake should be higher. And if they don't, maybe it shouldn't be. Like, you can get to that stuff through vesting schedules, or if you're worried they're going to leave because a better offer comes along, like, time-based vesting can be a really great way to deal with that. Ultimately, I think investors will want to see some kind of vesting for the founders, because investors are often, thinking about an investment as the team being part of the investment. They don't want someone to walk away. So all of those things can help kind of smooth over any questions a little bit. And then also, you will, in all likelihood, at some point, establish that equity incentive plan or stock plan. And so you have a mechanism there to true up ownership and also to compensate employees as time passes. So if someone begins with a small role, they're not maybe taking 10% of the company, but if in 6 months they're behaving like a co-founder, you know, you do have flexibility with the corporate structure to make those adjustments. Um, I would say that the biggest note of caution is really just to avoid gridlock potential if you can. So if you're a team of two, that can be really tricky. You know, if you maybe you are like contributing fairly evenly, it's worth thinking about what will happen if you don't agree, if you both have a board seat, if you have equal shares, like, is there an advisor who's like basically a tiebreaker at that point? Do you want to kind of pre-bake certain things that would require unanimity? And I don't know, there's not a lot of good answers when it's 50-50, but it's definitely something worth spending time thinking about. But other than that, I think that the best advice, or a good piece of advice I can give here, is really like to keep it as simple as you can. Time-based vesting is easy. If you can use time-based vesting and keep it simple, and everyone live with their allocations, that's probably in almost all cases, that's going to be enough to make sure everyone's incentivized to stick around and work on the company. But you definitely want to get to a point where everyone feels good about the allocations. And then as you are, continuing to grow beyond the founding team and ready to expand your team, there are a couple ways you might do that. You can hire employees and you can hire contractors. Whatever you do, it's going to be in the interest of the company in most cases to get that documented as soon as you can, preferably before they even begin working, so that you have a really clear trail that the IP, the intellectual property being created, is owned by the company and not owned by an individual contributor. And also that any confidential information you're sharing is protected. So that would happen through your employee offer letter if you're hiring an employee, and also a document that's called it's a confidential information and invention assignment agreement, or a proprietary information. It has like, I don't know, 7 acronyms and 3 or 4 different names, but it's some combination of those words, depending on where you find it. And I would say like every employee should sign one of those. If you have a consulting agreement, you want similar provisions in those agreements. Every consultant should sign one of those. And then beyond that, you also want to clarify other key terms of the agreement, obviously, like what the pay will be, what the scope of the project is, what the timeline is, especially if it's a consulting project. And those agreements can vary some based on state law. So this is probably another good point where like it's just worth a call to say, hey, startup lawyer, help me figure out like what state law I need to, what state law or laws I need to think about in these agreements. Usually, a lawyer can provide you with a form that can be used for most of the scenarios, so it's not a huge outlay of time. If you're hiring interns, proceed with caution, especially depending on the state. There are special considerations, but do also get an agreement for your interns. And then just a quick note on employees versus independent contractors, because it is one of the areas where companies can misstep. Companies have tax withholding obligations for employees and other obligations like unemployment insurance and things like that. So misclassifying your workers it's a pretty considerable risk, and you don't want to get stuck there. So using the correct agreement will help with that, but it's also important to just know the difference between the two. So, employees are entitled to wage and hour law protection, which means they have to get breaks for meals and rest breaks. They're entitled to workers' comp and unemployment insurance, all that stuff. So independent contractors are not, and they generally need to have a lot of independence in how they're working. It helps if they are doing this similar kind of work for other customers as well. California has this ABC test, which really kind of comes down to these same same things like what's the control the company's has over the worker? Like, is it outside the company's typical business? And, do they do this independently? Any of those things will help make it clear that you're working with a contractor versus an employee. Employee offer letters, there's a list here of different key terms just to make sure that you're covering your bases when you do write this stuff down. I don't think it's probably worth spending a lot of time on this other than just to say it's worth putting it in writing and outlining these things. I will just call one, like depending on how critical an employee is, like this prior employer information or any restrictions on what they should or should not be working on or have access to. Like the more critical a hire is, the more important and central they're going to be to whatever technology you're creating. It's worth some thought on that aspect, just because you don't want some employee's former employer, accusing you of stealing their IP by virtue of hiring this employee, because even whether they're right or wrong, if they have the resources to kind of litigate that could be a real pain for a small company just getting started. Other employment considerations: when you hire new employees, if they're remote, that may trigger a requirement to qualify to do business in a new state or a new jurisdiction. So that's something to think through. And often I think your payroll providers can help kind of guide you on that. Putting in some employee policies in place or a company handbook can be really helpful. Some states require specific policies. Some will only allow companies to enforce policies if those policies are in writing. Some policies are just a good idea, like cheap insurance for companies. So I would say, like, once you hit critical mass in terms of number of employees, this is another area where I would say, like, it's a worthy investment just to make sure you have some basics covered in a handbook. And then, eventually you probably have to part ways with an employee. Hopefully it's on good terms. That makes it easier for everyone. And if it's not, then you want to act with care in that regard as well. So on the main things I would think about, other than any like major risk of discrimination claims or anything like that, if you're worried about that stuff, definitely call an employment lawyer. Otherwise, I would say anytime an employee exits, voluntarily or otherwise, it's a good time to go back and make sure you have that IP assignment covered, that you're happy with the confidentiality obligations you've placed on the employee. Those are things that you probably, like, you may be asked to go get later in diligence if you don't have them. Always easier to do it at the moment in time when things are happening. And then if possible, particularly if it's a higher level employee, or if there's anything sensitive in the relationship, like to get a release of claims and just make sure there's not going to be like a surprise employment lawsuit filed at some point down the road.
Hey, Amanda, regarding the last point around employee termination and higher level employees, are there special considerations that founder needs to be aware of when another co-founder or founding team member is going to be parting ways with the company?
Yes, I mean, the main one that is, I think, more sensitive when it's a co-founder leaving than just an employee is likely to be what's happening with their stock, because depending on the relationship with the departing co-founder, you may or may not want them to have a lot of voice in terms of voting rights in your company going forward. So the bigger stake they have, I think the more of a concern that is. So if they're fully vested, you may want to have a conversation about buying their shares back. They may or may not be open to that. They may want to keep them. So that can be a pretty sensitive conversation. If they have a board seat, you need to think about whether are they also resigning from the board, or are they just leaving their operational role and then continuing to serve on the board? And if that's the case, what does that mean? Do they continue to vest in their founder shares? Are they still going to end up holding a really meaningful stake in the company? And is that okay with everyone? Those scenarios can look a lot of different ways. So it's just important to make sure, I mean, it, anything you can do to kind of leave things on good terms is probably going to be in the interest of the company in the long run. Anything within reason, of course. But I would say like co-founders leaving, like that's always going to come up in diligence with an investor. They're going to want to know the story. And so, you want to make sure you know the story also. But beyond that, the same like assignment of intellectual property and confidentiality obligations, the clearer those are, the better the company is going to be served.
Great. And then sort of a related question to that. I've heard in the past that the label of co-founder or founding team member is just a label where a founder or co-founder is truly only designated as a founder when they're present at the time of incorporation. Is that true? Do you have any thoughts around that?
I want to make sure I understand the question. So you're saying you've heard that founder is just a label, and also separately that you only the president is the founder. Is that what you're saying?
So I've heard that only those that are the team members that are present at the time of incorporation, putting together the articles of incorporation or are named, those are the ones that are designated as a co-founder of a company. Any persons who join the company afterwards are, even though you may call them a founding team member, they're essentially an employee.
I
They're
don't I don't think there is a single legal definition of what it means to be a founder.
Hmm.
I think it is really like what's the spirit of the relationship? Because I think if you are, what if you pivot, right? Like you start a company and then you do a complete, change of course, you bring in another person and they are really responsible for getting that project off the ground, and that's what ends up kind of becoming your company. Like I would think that person kind of has a founder role. There are times when founder gets defined in certain agreements, and so always I would look to that. But I do think from a like stock issuance perspective, there's something to saying like, oh, the founders are the people there at the beginning. I don't think that's like a legally binding construct, but I think that that's like sort of logical. And oftentimes, if you see a document called a founder stock purchase agreement, it's going to only be used at the very beginning before any value is created. But I'm not aware of any like specific definition that's become universal of founder. It's possible there is, but I haven't come across it.
Got it. Great.
Are there any other questions on this stuff?
No, I think we could continue. There are some questions that have been coming in, but I want to make sure we go through the rest of your content before we.
We will not. I'm realizing at 11:50. We can
We'll
we
do our
can
best.
get I think through this section, and hopefully people will leave us something valuable from that. So, and then I just wanted to spend a little bit of time on employee equity, not a lot, because I think this could be and even has been its own growth series session, but this can be a really important component of compensation. There are different types of awards that may depend on what stage the company is at and what the employee circumstances are. The options are the most common. They would be issued under a plan that would really simplify some certainty around administration and also tax and securities law compliance. So most companies adopt that kind of plan pretty early on. A note in here, it can also provide some certainty around ownership. And what I mean there is that if the founders own, 80% of the company before they raise any money, and there's an option pool that accounts for the remaining 20%. You can bring on employees without thinking every time about what your ownership is. It's going to be like at the floor of that 80% because you're kind of factoring in the dilution from the pool. So that's, I think, a feature of having that reserve and thinking about that as you're making the grants. And then I was going to spend just a little bit of time on commercial agreements. And Tony, you can tell me if it might be better to just spend time on the Q&A, or we could also, um, the last section I have after this is kind of about fundraising. So we could rapid fire either of those, or we could just kind of drill down into the Q&A, depending on what feels the most helpful with the remaining time.
Yeah, let's go through the commercial agreements section, and then we can reserve a fundraising session for a future dedicated one on fundraising.
All right, that's good because this is the shorter section by far.
Great.
So there are, varied and probably infinite different kinds of agreements that may be central to a company's business as they're growing. I've listed some of the most common ones here. And I would just say, as probably picked up on throughout the presentation, like it's really a question of like knowing your priorities, knowing where you want to invest your resources to be sure that you're getting something right. So whichever category of agreement is the most important to your company, wherever you're looking at generating the most revenue, creating the most liability for yourselves, I would spend resources, both your own time, your legal spend, any of that on those items. But I think it's helpful maybe to just be familiar with like the key contract terms that you're likely to see as other parties put a contract in front of you. So, you obviously want to know when a contract begins and how long it's going to be in place. The actual date can be surprisingly easy to overlook because sometimes you want to drop it in there at the very end of a process, a negotiation. But it does often tie into like notice provisions for whether the contract can be renewed or when it would be canceled. So it does warrant some attention. And equally important, I would say, is how long the contract remains in effect, what its term is. You want to clearly identify who the contract is between. If you have in the future a subsidiary that ought to be a party to a contract instead of the parent entity. Similarly, if you're signing a consulting agreement and you want a specific individual, but they have a business with other people, like it's, you want to make sure that you have the details that matter to you correct in your agreements. There's usually a section of recitals in a lot of agreements, and it kind of sits early in the agreement and kind of sets the stage or provides background about what the arrangement or transaction is. And it's not really where the legal heft of the agreement is, but it can, I think, be really helpful to clarify the expectations of the parties. And I think the clearer the expectations are, the more likely you are to have a successful relationship as a result of the contract. There are then like the real meat of the contract is going to be in these operational and economic obligations. So who is delivering what, when, how much will they be paid, how will they be paid, how frequently will they be paid, all of those details, again, there will be some that you probably care a lot about and some that you care a lot less about. And my suggestion is like it makes sense for businesses to negotiate accordingly. And so you really just want to, if you're going to muddle through reading a lot of heavy legal language, like spend your time on those provisions, because that's likely where you will feel the impact if you get something a little bit wrong. And then less exciting and hopefully never really that relevant, you really don't want to be on the hook for liability of a contract, beyond the value of that contract to you. You want to be really specific about what would constitute a breach of the contract that would give rise to any liability of it. And you usually want to be given an opportunity to fix a breach of contract. So anything to limit your liability or limit the liability of the other party is worth knowing about and paying some attention to. Also, you'll have the term up front, but you also may have other provisions around the termination of the contract, whether people can terminate early, what happens if, there's a product being moved in the midst of that cancellation, what are the payment obligations, what is the notice required. You want to be aware of those terms. Again, like the magnitude of the contract in terms of it's important to your business is corresponds to the level of attention that you want to be sure to give the contracts on the whole. And then, as always, I mean, I think it's come up in every section of this presentation, but protecting your company's IP, whatever your secret sauce is, you don't want to give it away. And similarly, if you have a contract that, will cause your company to rely on someone else's IP, you want to make sure you understand the terms of the license and your freedom to use that going forward. If it's not a great relationship, but some component of it's working well, do you have a right to continue to use it? If they're building it for you, they should be assigning it, but also maybe there's a component that they're maintaining ownership of, and you just need a license to that for, until the end of time. Like those provisions can be really important, and you just want to make sure things are carefully spelled out in the agreement. So that's my very few minutes on commercial agreements, and I'm going to stop there because we have 2 minutes left and we can go through any questions. Should I stop sharing, Tony?
No, if you don't mind going to, did we include that final slide with next steps? If it's in this deck, if you could just flash that while we wrap up. I do want to address just a handful of questions, maybe two at most, in the minute and a half that we have left. So the first question, which I get a lot, not necessarily from Mucker Portcos, but just in the startup community in general, is when should a founder engage with legal counsel? At what stage does it become where we need to make sure we have, a lawyer on the team, or, someone who we could turn to in the startup journey?
Yeah, I mean, I would always say that earlier is better. And I'm sorry, I'm trying to get this screen back up and I can't do it. I have to go through the whole presentation again. Earlier is always better. If you have the resources to start a relationship with someone, I think that many startup counsels are very used to dealing with companies where you may call them to form the company and then they don't hear from you again until you're ready to raise, or you're hiring, a CFO or someone really critical to the company's growth. That's a pretty normal relationship for those lawyers to have. And so you should never not hire them because you feel like you won't talk to them enough. They understand that they bill by the hour and you don't really want to talk to them. So earlier is better, but if you're a little ways down the path and you are still trying to figure out, I would say, like, anytime something is keeping you up at night, it's probably a good use of your time to reach out to someone.
Okay. And then one last question, it's sort of a two-part question. Are there any resources or tools that you feel like would be a good, not necessarily, obviously not a replacement for, a live human legal counsel, but are there tools like Gust or Stripe Atlas that can help with things such as putting together your, incorporation documents or managing your cap table, that you have found or have seen to be useful, or at least prepares a company in the best way possible?
Yes. So I think that there's everything in this presentation. If you want to drill down on it, you can go and find a lot of really good information out there. Some of the big law firms who do a lot of this kind of work are especially great resources, and several of them have document generators, I think. So I know I worked at Cooley for years. They have a website called Cooley Go. I think they now have a chat bot, but I haven't tried that feature. But you can generate incorporation documents there, and they're going to be pretty good documents. I still probably wouldn't recommend operating your business for years using only those documents. I think there just comes a time when having sort of dedicated attention that's not generic is going to be in your company's interest. But I think a lot of those resources can be a really good starting point. I don't think I've seen one for cap table management that I think is great, but I haven't, the ones that were mentioned, I actually haven't seen. So maybe, shoot me a note. I'd be curious about it. But, if your cap table is simple early on, like, just maintain it. Just maintain it in a Google Sheets or an Excel file and, you know, update it. And it won't be, even if it's not perfect, like it will be way better than just trying to go back and dig up all the documents and tie it out later. That's my best advice on that one. But I do think there are always new tools emerging, and often they don't start out great, but they get there. So I wouldn't be afraid to try it, but I think checking in with an expert once in a while is still the way to go.
Great. Thanks, Amanda. Amanda had the daunting task of trying to cover everything under the umbrella of Legal 101 for startups in this short amount of time. But hopefully we were able to get a lot of the basics down, answer some questions that people had regarding, legal considerations throughout their startup journey. Amanda, thank you for sharing your knowledge. Thanks for spending time with us. Thanks, everyone.